So I'm going to talk about the ethics of deportability. In a moment I'll define what I mean by deportability, because it's a kind of strange word that perhaps some people won't have encountered, so I'll set out what I mean by that. In terms of the ethics bit, I'm going to leave that till the end. Okay, so I'm going to talk a bit more about deportability in general, what that means, what the current trends are, and what my findings are in terms of kind of the international dimension of deportability, and then the ethics kind of comes at the end. You know, what can we do about this? Can we do anything about what I'll show is a sort of increase or an expansion in deportations and in deportability. So maybe we can have some discussion around whether people think anything can be done about this or needs to be done about this. Actually, we booked this slot months and months in advance, I think, but it's actually turned out to be quite a nice week to talk about deportation and deportability. I think actually it was last week, the parliamentary committee released a report on the use of detention prior to deportation in the UK, and the parliamentary committee actually ended up being very critical of what we're doing at the moment in terms of detaining people prior to deportation, or while we're processing their asylum claims. So it's quite topical at the moment, and I follow various anti-deportation groups on Twitter, for example, and there are ongoing big campaigns in civil society to try and draw back a little bit from the current situation in terms of deportation and deportability. So it's a really, I would say this, but I think it's a really topical area of discussion. Okay, so a note then on terminology before I sort of start properly. So clearly what I'm looking at is the broad topic is deportation, by which we mean roughly the forceful physical removal of a person from the territory of a state. Okay. Most often these days from liberal states, most often from the UK, we do that via planes are chartered to remove and deport people. But it is, and I'll say a bit more about this later on, it's generally, essentially, it's coercive. You are generally moving people against their will, physically removing them from the territory of the state. States have various different terms that they use when they're talking about deportation. Sometimes they don't use the word deportation, they'll talk instead about removal or readmission. Sometimes it's talked about as expulsion. I'll follow the convention in what I'll talk about in a minute, the deportation studies literature, which is to sort of accept that all of these terms really are referring to the same act, essentially, okay? And there's a semantic sort of argument to be made about which we should use, but we tend to, or the literature tends to use them sort of interchangeably to some extent. The practice in the UK is usually to talk about removals. And I'll talk a bit later about the European Union context, and within the European Union there's a big drive to seek readmission, so there's a lot of talk about readmission, which sounds a bit nicer somehow. If you're kind of readmitting people, the emphasis is, it sounds a bit more welcoming, not necessarily the case. Okay, so I'll use these terms sort of more or less interchangeably. I'll talk probably mostly about deportation. Deportation, as I'll go on to say, is an important part of state sovereignty. Okay? It's an important power that the state has, and that it recognises other states as having. So it's an important part of international relations, which is my background. However, this is a quote from Matthew Gibney, who's one of the sort of foremost deportation and studies scholars within my field, within politics. And he's noted, absolutely rightly, that deportation is a complicated and controversial power. Okay. Already, okay, and I'll demonstrate that this is correct when we look at the international framework in international law for removals and deportation. It's already quite complicated. It's not a clear-cut state power. I'll talk a little bit as well about deportability, and what we mean by deportability is the sort of broader conditions under which it's possible to deport someone, right? So I'm not going to talk very much about specific deportations, although there's lots of interesting things that could be said. There are lots of horrible examples of deportations that have gone awry in the UK in recent history, where people have been severely injured or even killed during attempts to deport them. So it is a very controversial, and Gibney also argues that it's a cruel power as well, okay? Particularly when it's enacted by a liberal state, which holds itself to a liberal standard. So deportability then is, as I said, the sort of wider conditions under which deportations are made possible. And this has a specific meaning in international relations theory, which I'll come back to a bit later on. International relations theory, which is my discipline, is very interested in how things are made possible. Okay, how is it that deportation is seen as legitimate? How is it that it comes to be such an important aspect of state power? And also, from the ethical point of view, how might that be different? How might how might we get different conditions which might lead to a decrease in deportation? Right, so deportability, more or less synonymous with returnability, the ability of a state to deport someone or return somebody. I may also, I promise I'm not just making up words, but also talk about undeportability and unreturnability, right, which is the condition when a state finds itself unable to deport or return someone that it would like to do, that it would like to deport or return. And that leads to a sort of deportation gap, which I'll talk about shortly. While I'm on terminology, and I'll finish on this soon, I may start throwing in the words of norms and practices and discourse, which are words that are used again an awful lot in international relations theory, so I should say a little bit about how I'm using those terms. So norms, in a general sense, I'm talking about the sort of general standards and expectations that govern relations between states. So I'm talking about international norms and how those sort of shape and give meaning to the way that states interact with each other. Practices are the things that states kind of habitually do, okay, the things that states tend to do and engage in, and discourse is the way really that those practices are kind of legitimated or justified, so on. So yes, if that's not clear later on, please do pick me up on those terms. Right, okay. All right, so the research question that I'm trying to answer in this, this is an article which I'm still working on at the moment. It's been going on for a while in various iterations, and I'm working on it now. The question that I'm interested in asking and answering is, how does deportation generate conflict on this quite normative question of who belongs where? Okay. This is an important, as I'll show, an important aspect of international relations, deciding who belongs where, dividing up populations between territories, and so on. But as we'll see, it's not a question that has a straightforward answer. There is no simple way of deciding across the world who belongs where. Okay, so it's very complicated. I should say, if I don't have this on this slide, it's on the next slide, this is building on existing work in the deportation studies literature, which has looked more at the way that deportation generates conflict over who belongs inside with us. So, for example, Matthew Gibney, who I've already mentioned, and Bridget Anderson and Emanuele Paoletti have a really interesting article that looks at the way that deportation causes conflict within the state, causes people to really discuss and argue over whether these people have a right to stay and whether they have a right to belong. So it causes disagreement and conflict and contestation over these questions. I'm trying in this article to build on that and look at the international level. How does it generate conflict at the international level of thinking about who belongs where and how we should administer that? Okay, so the preliminary findings of the research on this show that deportation both reflects existing conflicts in international relations and also generates further conflict on this question. This is possibly, as I'll go on to say, an area in which we can see potential in ethical terms. Okay, so possibly this fact that it is a highly political, it's not settled, it's political, it's open to discussion and contestation. Possibly this means that there is scope for, a better solution. In terms of the ethics, I'm taking for granted that deportation is sometimes going to be unjustified. Maybe I should say that straight up. It's cruelty, it's violence, and the way that, particularly some of the violent tactics that are often used, do seem to be particularly, ill-suited particularly to a liberal community. And as I'll go on to say, that's the reason why lots of these things are often done in secret, and governments try to keep them quite quiet and so on. So maybe I should say that straight out. I'm taking for granted that there is some kind of ethical problem here. There is some kind of problem in the way that we're using deportation today. Okay, so what I want to look at is the deportation turn, and again this is a phrase from an article by Matthew Gibney, and he provides evidence of a significant increase in the use of deportation really in the last, I guess since 2001. He traces it back to about 2001, so that's sort of 14 years. And he looked particularly at the domestic kind of the politics of that. So there's quite an interesting article that looks at the way that successive governments in the UK and oppositions in the UK have sort of used control of borders and immigration as a kind of political issue. So he identified what he calls this deportation turn. And other people have pointed to this as well. An important article by Alice Block and Lisa Schuster talk about the normalisation of deportation. And this is important because actually for a long time in the, particularly in the 1990s, but even before, deportation wasn't very routinely used. We can know this because the government produces its own data, which, presuming we can trust its accuracy. The government every year produces data on this kind of issue, so the number of people that are forcibly removed, as well as the number of people that voluntarily depart, alongside data about the number of asylum applications and the number of grants of asylum and so on. So we have data which we can use to identify this deportation term. Interestingly, perhaps, deportation has actually fallen slightly. I mean, I don't think we should necessarily infer too much from this, but deportation and enforced removals fell by 6% between 2013 and 2014. And I've just got some data here just to show you. So I'll start with this table down the bottom here. This, I just picked out the data. This is from the government's figures in the UK over 3 years. And we can see, again, I'm not a quantitative researcher and I wouldn't want to infer too much from this, but we can see things are broadly static. However, over 3 years, the number of enforced removals has fallen slightly year on year, and the number of voluntary departures has gone up slightly year on year. And I'll speculate a little bit a bit later about why this might be. Part of it is possibly because of the constraints that do operate on deportation. It is, as I said earlier, it's a controversial power. What we have up here is some figures on applications for asylum across that same 3-year period. So we can see that applications for asylum have gone up, slightly year on year, and accordingly the grants of asylum, so the successful asylum applications have gone up year on year as well. It suggests a sort of steady-ish situation. All right, so what this might suggest is that the deportation turn is slowing down a bit, but it's a little bit early to say. This is just over a kind of 3-year period. It would be interesting to watch over this going forward. Right. Okay, so to situate my approach to this, I'm trying to situate deportation and deportability within the sort of wider field of political and administrative practices. What I kind of mean by this is what I said earlier. I'm not looking at specific acts of deportation. I'm looking at the wider political and institutional context that in which this turn is situated. There's some quite helpful literature on this within deportation studies literature, which I should say is it's a fairly niche kind of literature. It's not been much studied over a particularly long period, but there's a seminal article by William Walters in 2002 which highlights the role of deportation in making the world. Okay, so his basic argument is that deportation, we should be looking more at deportability because deportation sort of constructs specific aspects of world politics. Okay, so what he's saying really is that communities, for example, states, are partly shaped and constructed through who they decide to exclude, and those kind of final fundamental decisions about who cannot be on our territory, who we must remove. So those kinds of decisions have quite constitutive effects. Okay, they help us define us against them, insiders against outsiders, and so on. So there's another nice quote which I haven't put on here. He says that deportation is a way of what's the phrase? It's about the international police of aliens, okay? It's a way of, if we look at the broader practice, a way that states sort of police who goes where. So this is the question that I set out at the beginning that I'm interested in, this question of who belongs where. And Walter suggests that this is related and sort of doesn't, at that point, take it too much further. As I think I mentioned earlier, there's also some interesting work which we can draw on, which shows the ways in which deportation actually, at the domestic level, helps us define, you know, who we are. What kinds of refugees are we willing to accept? What kinds of refugees do we not want to accept? Who do we not deem refugees? Who do we deem worthy of deportation? These things get to the heart of how we, you know, define ourselves as citizens and as nations. So what I wanted to look at, as I said earlier, is the way that deportation, the functions it serves at the level of international politics. So what I set out to do in order to answer this question was to look to start with at two areas. So the first one is to look at the sort of the sources of international law, which help us make sense of deportation. So I'll talk about that in a second, and then I'll go on to talk a bit about the sort of bilateral nature of deportation, the specific sort of agreements and political discussions that state leaders get into about questions of deportation. And the reasons that these arise is because, as I'll show in a minute, when you're deporting someone, you need to know where you can deport them to. Okay, you have to have somewhere you can send them to, and generally speaking, to some extent, you will have to have the agreement of that state that they will take that person back. And this is part of why deportation is controversial, and there can be gaps that arise there. So I'll talk a little bit about those in a second.
Sorry, one question.
Sure.
So this means basically that stateless people cannot be deported, right?
It does. I'm glad you asked that. You figured I'm going to talk a little bit about stateless people. Absolutely. Formally speaking, stateless persons cannot be deported. Informally, states have been quite innovative and quite adaptive at finding ways of getting rid of stateless persons throughout history. There are various constraints, so I'll go on to talk a little bit about it, but you're absolutely right. Formally speaking, stateless persons can't be deported. And actually, the reason for that is not so much to do with the rights of the stateless person, right? It's to do with sort of international burdens, right? Putting a burden onto another state by kind of shifting your problem onto them because of their ambiguous nature.
And the same applies to the opposite pole with people holding dual citizenship, for example, because who's the state responsible, the country of origin, responsible for that individual?
Yeah.
Which one of those two?
Absolutely, and there's no kind of international court that can really has the authority to arbitrate in those kinds of decisions. There are some interesting cases actually where the International Court of Justice has sort of, I'll talk about one a bit later, has sort of tried to rule on those questions. And for a long time actually, maybe you already know this, states did not like people having dual nationality. For a long time it was not possible, right, to have dual nationality in many states. For questions of loyalty, right, knowing which state the person was loyal to, particularly in an era of more traditional war where you needed to know that you could conscript people for military service, but also for this kind of question of deportability, knowing where to remove people to, absolutely. So yeah, you're absolutely right. Those are two sort of cases which create an ambiguity, right, in terms of deportability. Absolutely right. Excellent. So I wanted to research really a bit more about the effect of deportation on international relations, right? That's the kind of broad thing I'm interested in. International relations, one of the sort of key insights in recent years of international relations theory is really about the way that binaries of sort of inside and outside, the exclusions and the violence that they generate, right? This has been a sort of a key discussion in IR theory. So IR theory recently has been pretty critical of the state and the way that statehood promotes exclusion. So this is a quote from Richard Devtak. It promotes exclusion, it generates estrangement and injustice and conflict. The state is seen in quite critical terms. So the idea really is that the imposition of these kind of ostensibly rigid boundaries, as we'll see, they're not necessarily particularly rigid boundaries, has, again, constitutive effects on the world. So, you mentioned statelessness. This is something that I've been interested in for a few years. one of the major kind of binaries we can see when we look at personhood in international relations is that between citizens and stateless persons, right? So, okay, you know, there's a difference between citizens and aliens, but aliens are citizens of somewhere, right? So we all have this kind of a certain set of rights. Generally speaking, citizens have the right to return to their own country. They have a kind of right of residence in their own country. And exactly as you said, stateless persons lack those rights and lack that certain status. So there's a kind of stark opposition there between, you know, the norm, if you like, and the exceptional situation of stateless persons. So, absolutely, stateless persons can well be seen as demonstrating the sort of limits of the existing system of belonging. So, I asked this question about, you know, there's this kind of normative question of who belongs where, and states are very involved in trying to kind of answer this question. It's often quite political, and we can see that it's a question that can really potentially never be finally resolved, because, as we'll see going forward, states have sovereign rights to determine their members, right? And in certain situations, states still reserve the right to denationalise people and so on. So, yeah, statelessness is an ongoing problem, which sort of shows the limits to our present system. So there's a nice quote from Hannah Arendt that maybe some people will know, where she says that only with the complete organisation of humanity could the loss of home be equivalent to the expulsion from humanity, right? I've not quite quoted that correctly. But it's the idea that actually by, you know, developing such a comprehensive system of statehood and border control and trying to ensure that everybody belongs somewhere, by doing that you've raised the costs of being excluded, right? Being stateless didn't used to matter so much, and now it matters an awful lot, because the norm is that everybody belongs to a state, right? Okay, so, all right. So, the stateless person, as you rightly pointed out, are the kind of paradigmatic, or is the paradigmatic undeportable person, right? Deporting stateless persons is difficult because you don't know where to deport them to. No other state's going to want them because they don't know where to deport them to. And so we saw after World War II, Hannah Arendt writes about this, the stateless persons were often kind of pushed around over borders. Nobody wants them. And in her phrase, they become seen as the scum of the earth, right? Nobody wants them because you're stuck with them. You didn't ask for them, they arrive and you can't get rid of them. This principle that you should not deport stateless persons is found in various sort of aspects of or expressions of international custom, right? So in 1949, the UN set out a study of statelessness, which sort of articulates this international custom that no state is bound to receive a stateless person in respect of whom an expulsion order is issued. So saying, you know, you can't just order an expulsion issue for a stateless person because that would cause a burden to another state. And this shows actually something that I'll come back to later, that deportation is generally a bilateral issue. States can't generally just unilaterally expel anybody. They do need the agreement or you know, explicit or tacit of another state. So what we see when we look at statelessness in trying to understand this broader question of, you know, who belongs where, is the vital importance of legal personality, which is an expression that captures the international dimensions of nationality, right? That it kind of gives you a legal personality that you can travel with, that will be recognised in other countries than your own. So we see this attempt at a kind of complete organisation of humanity in Arendt's terms, through the development of international relations, through the history of the 20th and 21st century, and there seems to be this kind of quest for, you know, a full and final allocation of subjects to sovereigns, an attempt to, you know, distribute people and administer populations so that everybody does belong somewhere. As we've already seen, given the ongoing occurrence of statelessness, this is proved impossible. States find it very difficult to, you know, to separately or together to finally allocate people. Okay, so I should just point out that in doing this, okay, clearly this has led to the development of certain important rights for individuals as well. Okay, it's not purely a sort of, you know, an exercise in state power. The development of nationality and citizenship has clearly led to important rights. Not limited at all to these rights, but these are interesting ones in terms of the international dimension. The right to recognition everywhere as a person before the law, which is the Universal Declaration of Human Rights, and the right to leave and return to one's own country, which again is in the Universal Declaration of Human Rights. So in doing this, they have created rights for individual persons, without doubt, but there's been a sort of a state logic of exclusion driving it, I would argue. Okay. So I've said this already, I think legal personality is the formal basis of deportation, right? Identifying where somebody belongs and returning them. And as I keep suggesting, it's not always that simple. This is, as I've said, it's related to a state right to demand from a state of nationality the readmission of its nationals, okay? The idea that migration is partly facilitated, I would argue, by the fact that it's kind of temporary. There is a general assumption that people will or can go home, and this kind of gives meaning to, I would argue, to contemporary migration. When we look at the picture within sort of international custom and international law, states have a right to demand the readmission of another state's nationals. It's generally been argued that there's a customary, unfettered right of deportation. However, that has been subject to various limitations, which I'll talk about in a moment. And I should also mention this associated right of the state to determine who are its members, right? States get to decide their own criteria for membership, nationality, immigration, all those kinds of things. Those are arguably remain quite firmly within the ambit of state sovereignty. So what we find is this sort of situation where the sovereign system seems to demand certainty about where people belong, but doesn't really have the conditions for that certainty because it allows each state to determine for itself who its nationals are. So stateless people result, states exclude people for various reasons. So it's sort of a strange logic. We see this a lot in international relations. It's often called the kind of tragedy of international relations, or the dilemma, is that there's this sort of need for certainty which is it's elusive because there's no authority above the state to make decisions. States having sovereignty, engenders limits. Does that make sense? This is something we talk about all the time in IR, and we kind of so it's this idea that I mentioned earlier that the system of sovereignty, of state sovereignty, inevitably has exclusions, okay, because states are able to make decisions for themselves about who to include. Clearly, I wouldn't like to suggest there aren't limits on that. The development of human rights and the development of the rights of non-citizens and so on have clearly made changes to this, and again I'll talk a bit about some of those constraints going forward. Right. Okay. This is just a quote from the paper in draft form. What I just want to highlight now, and again this is a key theme for the rest of my talk, this sort of ambiguity and this sort of conflict and this drive for certainty has led deportability to be an area of quite some innovation. States have proved quite clever actually at deporting undeportable people and therefore shifting what counts as deportability. Okay? And I'll give some examples of this. So states have learned how in various situations to secure readmission even in the absence of formal legal personality and in conditions of uncertainty. And I'm trying to argue this is really important for us to understand if we want to understand these kind of questions in international relations. Okay, right. So, just then to draw this back to the deportation and sort of studies literature, as I said, and there's been some really interesting work that's looked at the impact of deportation in domestic questions of belonging. And they've highlighted the way that, on one hand, there are constraints that limit who states can deport, but also the way that states have kind of resisted these constraints. And there's quite an interesting story about how they've done this, and lots of people have already found this. So I'm going to move to talking now about some of these limits to unreturnability and the way that states have kind of resisted these. Sorry, the limits to returnability, right? The limits to who you can deport. This, I mentioned this phrase earlier, I think it's a really nice phrase, there's a deportation gap between the amount of people, the number of people that a state would like to be able to deport, and the number of people it can actually deport. So for example, states deport all kinds of people, foreign national offenders is one group, but also the largest group, failed asylum seekers. So the deportation gap, would be on the one hand you could count all of the number of people eligible for deportation, failed asylum seekers, foreign national offenders, and then the number that are actually deported or are ready for deportation or so on, and there are various statistics. Right. Okay. So what defines this deportation gap? How does this gap arise? We've already talked about some of the cases. So stateless persons are a sort of obvious case and a really important case where they are at first glance undeportable, right? Because where do you send them back? You shouldn't just push them out, because that will, you know, your neighbouring countries will be frustrated with you, and it will be bad for international relations. And you actually find this if you look at the sort of preparatory work behind the drafting of the Statelessness Convention. You can see this concern expressed, absolutely. So again, there were words used like, we don't want to be a dumping ground for stateless persons, because states were worried about not being able to get rid of these people. I haven't said this yet, but I don't think, but I should also say citizens are generally seen as being non-deportable. Okay, this is, like as I said, you know, generally we have the right of residence by virtue of being citizens. So generally speaking, citizens are not deportable, although sometimes citizens can, you know, tip over into becoming stateless. Although again, there are some restrictions on this. Refugees, people that are recognised as being refugees, as having a proper claim to refugee status, are undeportable, generally speaking. So the 1951 Refugee Convention, which again I'm assuming most people know about, and the 1967 Protocol set out provisions for non-refoulement by which you cannot return someone to the territory where his life or freedom will be at risk. Okay, so refugees are generally seen as protected. These categories of people are protected from this kind of cruel power of deportation, and arguably that's what the Refugee Convention does actually. It's not about protecting the citizen from their state of origin, it's about protecting them from deportation, protecting them in the state in which they are being hosted. There's another category of persons here as well, persons of just uncertain status, which can include just people who have destroyed their own documents in order to try and become undeportable, and can include people, I don't want to get too much into this, but there's a discussion about de facto statelessness and how we define statelessness as well. Sometimes unaccompanied minors can fall into this category as well. If you get children turning up, it can often be very difficult to ascertain, you know, what their status is, and so on. So these are the sort of groups of people that are often considered to be undeportable. Yeah.
One question for clarification again. A group of citizens within the framework of the European Union also includes intra-EU migrants?
Sorry, can you just, I think I get what you're saying. Can you just say that again?
If the group of citizens includes also EU citizens residing in another member state? Because
yes,
in France there have been some problems regarding the deportation of Roma.
Yes.
Actually, citizens of Romania residing in France.
Absolutely, absolutely.
Maybe question.
Yeah, well, I guess my answer would be in a sort of simple way. Yes and no. It is, EU citizenship does grant certain protections from deportability or deportation, but it's not. There are provisions within various treaties of the EU by which you can. So for example, even in most of these cases, refugees, for example, states can, if they deem it that these persons are a threat to state security or something like that, actually they can be. And again, I'm not a kind of specialist in EU law, but there is provision to deport EU citizens if they are, if it's deemed necessary, or particularly for reasons of security. But yeah, absolutely, they are more protected than aliens generally, quite a lot more protected. Okay, so those are the kind of obvious kind of categories of persons. I can see a question coming up at the end. Those are some of the categories of people that fall into this deportation gap that states might like to deport and don't, or just people that aren't eligible for deportation. There are other kind of gaps that arise to do with normative and legal and practical constraints actually. So I've already mentioned the 1951 Refugee Convention and the 1967 Protocol, which limit state power of deportation. There are also limits which arise from other aspects of international law. So the Convention Against Torture, again, sort of formalises this idea that you should not deport someone who is liable to be tortured when they are returned. The European European Convention on Human Rights and the European Court of Human Rights often limit deportability as well. One of the provisions that's often used is the right to family life. So it might be that an asylum seeker has been in the UK, let's say, for a number of years while their claim's being dealt with. In the meantime, they've had, they have a family, they've perhaps got married, they've had children here. This might make them undeportable, legally and practically speaking. There have been cases where the government's tried to remove these people, they've taken it to the European Court of Human Rights, and it's been decided that no, it would violate their right to a family life to deport them and leave their British children behind, say. So this again imposes limits on the state power, you know, and probably you would mostly think these limits are good things, right? These kind of, you know, these set out important claims to be allowed to remain, to be undeportable. Again, he talks about this again. Domestic liberal norms and domestic law can also operate as constraints, particularly when it comes to deportation where you really have to use force. I mentioned this earlier, where you're talking about drugging people or shackling them and dragging them onto planes. You know, this will not always go down well with domestic publics and so on. Sometimes it might do. So this is linked to kind of the constraints of civil society. One of the constraints that often operates is, and this relates to the family life actually, is that for example, asylum seekers become integrated in society as well while they're waiting. So maybe through having a family, but may just be that they, you know, they are integrated in a local church or something like that with their neighbours, and that creates a practical constraint in that, you know, their communities do not want to see them go, and you'll often see quite impressive campaigns really to, you know, to keep people, you know, where they are. Yeah. Okay. So this shows, I guess, this idea of deportation power as being a bit controversial and contested and limited. Okay, it's not, as we saw earlier, there was a sort of custom that states were competent to expel at any time whatsoever any migrant, you know, for whatever reason. That's no longer really the case. There are various constraints on this state power. And yet we witness, arguably, a deportation turn. So how are we to understand that there are these constraints and that states have still managed to ratchet up deportations in the last sort of 14 years? Well, they've proved quite adaptive in circumventing and getting around these constraints. I'll move on to that in a second. One of the other constraints that I should have mentioned, this is, some people argue this is the major constraint on deportation, is getting the cooperation of the state, or a state where you want to send them, okay? So I mentioned that deportation is generally a bilateral thing. You need the agreement of a state to take the person back, to readmit them. What's interesting is that states have realised that there's scope for leverage here and for bargaining. Okay, you want us to take back all of these migrants? Well, what do we get? And this is, you know, this is to be expected from a standpoint of international relations. You know, again, there's no authority above the state to kind of, states have to work these things out for themselves on a kind of, you know, political quid pro quo basis. So there's some quite interesting developments there as well. So yeah, this relates to a kind of broader coordination problem in international politics and to power inequalities as well. Okay, so what you find then in response is that the EU has tried to kind of work together to do this, to kind of, you know, to demonstrate its muscle against third countries that it would like to, you know, send people back to. Okay, so okay, I've hinted that states have tried to kind of resist these constraints. So how have they done that? In various ways. Okay. This is a long-standing problem, this top one, the refusal to recognise statelessness. Again, Hannah Arendt wrote about this back in the 1940s. States will often try and argue that people aren't stateless, or try and contest the meaning of statelessness, and will try and get around that, you know, that limit on expulsion. A situation that affects a greater number of people is a situation of refugees. There's a huge literature on this that some of you might be familiar with, about recent innovations in refugee status determination, extraterritorial refugee processing. It's back in the agenda again. You know, should the EU offshore its asylum procedures? So states approved, and there's Alexander Becks has written on this a lot within IR. States have found really interesting ways to try and interpret and arguably limit their obligations under the Refugee Convention. In terms of persons of uncertain status, as you might expect, they try and, you know, get certain about where these people should belong. So most states today that are sort of host states, okay, so the richer developed states that are the ones that are trying to deport people usually, they've generally developed quite interesting technologies of trying to work out where a person's from. So things like language and, you know, by interviews about their culture and so on. States try to really make people deportable in a range of cases. All right, so again, resisting this deportation gap, I've suggested this already, there's quite a bit of scope for interpretation in terms of how states apply the provisions of the Refugee Convention, and one of the things you probably know again is that the EU is trying to sort of harmonise its approach and to have a coordinated approach to this through various aspects of EU law. When it comes to the Convention Against Torture, which places limits on deportation, they do things like they try to obtain assurances. You know, please promise us that if we send this person back to you, you won't torture them. Because clearly, I should have said this perhaps, not all states are signed up to the 1951 Refugee Convention or the Convention Against Torture. So, so this is maybe not the best case because he's not the most sympathetic character, but in the discussions of the deportation of Abu Hamza to Jordan, right, the Home Office were trying to get assurances from Jordan that he would not be tortured if he was returned. They were trying to make him deportable, right. I've mentioned these as well, but so the European Convention on Human Rights has often been used to stop deportations, to limit deportability by referring to the right to a family life. So there are some quite upsetting things that states have done in terms of trying to sort of separate families, make asylum seekers destitute so that their kids are taken into care, and so on. Terrible tactics. I mentioned this earlier, so the extent to which domestic politics can constrain deportability, states will often try and do these things in secret. They know now that deportation flights are not popular and will often be, challenged, so they try and keep those kinds of things quite quiet. And again, we see that it's contested because civil society groups will, try and find those things out and challenge the state when it's doing these things. There's one more interesting point to make here about the integration of asylum seekers. There have been very deliberate policies of detaining and dispersing asylum seekers, so locking them up or sort of spreading them out around the country to try and stop them becoming too integrated in communities. There's a really interesting literature on that. I'm aware that I've already started to go over my time, so I'll just say something more about the way that the deportation gap has been resisted through the use of readmission agreements within the EU. I won't say too much more about this. So an important aspect of the EU policy on this has been to try and get agreements with third states that they will readmit people. What's particularly interesting about this is the way that it is that the result of kind of bargaining. It's often tied up into trade deals or sort of visa deals in which states are kind of induced to take people back. And what's particularly interesting in terms of thinking about deportability and who belongs where, is that these readmission agreements often require states to accept back stateless persons or third country nationals. Okay, so it's not just about taking back their own nationals, it's about taking back other groups of otherwise undeportable people. So I wanted just to try and put across in these kind of 45 or so minutes is that absolutely deportation is a right that states seek to enact and seek to extend, but it's controversial. There are various limits on it, and yet these limits are often resisted by states. There's scope for contestation here. In spite of my discussion with Bernard at the moment, I'll leave aside the methodology and I'm happy to answer questions on it. What I want to do in the fuller version of the paper is look at the way these norms are resisted and challenged. There's a framework within IR theory that can help us do that and understand the deportation term in IR a bit better, in a nutshell. So yes, I'll leave it there, I think, and be really happy to answer any questions.